You all aren't going to believe this. I was cleaning out a folder and I found an update to the wild custody hearing. I know. Shame on me. For those of you who did not watch this previously, let me give you a short recap if I can. This is probably the wildest custody case I have ever heard. It's absolutely crazy, and I'm not even sure how to really recap it, except to say mom and dad had a very, very, very toxic relationship. They moved from Texas to California to Iowa to Michigan. When they left Texas, dad had several warrants out for his arrest. He was actually on the Texas 10 most wanted list. He has since returned to Texas. Pretty much all of those charges have been dropped. He does have an extensive criminal history, arrest-wise, but very few were actually prosecuted. I went over that in one of the previous videos. So they're living in Michigan. Mom decides to leave, and she takes off with the kids and goes to Indiana. Dad finds them, takes the child back, goes back to the house. Mom returns, and this is where this clip comes in.
Kelly, you had said that I abducted your children, your child, your son. Is that correct?
You did abduct Hunter.
Okay. What is your definition of abduction?
Taking a child.
Okay. Would that be something that you did when you left this house?
No, it would not. Considering I was taking my children out of a violent environment.
It was a yes or no. Thank you.
So when mom returns, she ends up taking the kids and taking off again, but this time she doesn't tell him where she goes, and it takes him a while to figure out that she went to Texas with her family. So she just often left the state. So this has been going on for over a year, where dad is trying to regain custody of his kids, and the court entered an order for supervised visitation because mom's claiming domestic violence, and they haven't made it through the court system yet to prove one way or another. So there is a service in Texas that is supervising visitations, and if dad wants to visit in person, he has to drive from Michigan to Texas. So this is the testimony from the person who is supervising the Zoom visits.
How would you describe his attitude towards Miss Reed?
Berated, bullied. He can verbally attack. Somewhat narcissist. It kind of gives me, to be honest, PTSD.
It gives you PTSD?
Yes, it's a trigger for me, unfortunately.
Now, this woman and her company decided that they were no longer going to supervise the visits because she didn't feel comfortable supervising him. It's hard to tell who's telling the truth and who's lying, because then the child was in the hospital and mom got caught in a lie in this instance.
Hard. How long was Hunter in the hospital?
3 days.
3 days. So you made a statement earlier that you were messaging me back and forth and you couldn't deal with that while you were in the hospital, but I didn't get your message till 5 days after you sent it. I'm trying to come up with a timeline here.
That's fine. Yes, I didn't really respond to much on my phone due to the fact I had to lay in the bed with a 3-year-old who had a tube down his throat and was trying to pull it out along with his IV.
I understand. I can only imagine.
Hospital.
No, I'm just trying to come up with a timeline, Kelly, is what I'm trying to come up with.
To give you that timeline, you started asking questions about needing to know doctors, hospitals, this, that, and the other, but I had to have proof for everything that I was saying.
Ma'am, I just need you to answer the question. You said that he was in the hospital for 3 days, correct?
Correct.
Okay, I responded 5 days later because I'd never got a message from you on Family Wizard. That's on the exhibit that your lawyer submitted. So were you in the hospital for 5 days or 3?
He was in the hospital for 3 days.
Okay, you just stated that you couldn't argue with me while you were in the hospital because you were taking care of your son, but I never even got the message till 5 days later.
I don't believe that's what I just said, but okay. ultimately, I just got harassed because he didn't believe any of it, and I needed to show him proof of everything that was happening while I was sitting in ICU with a 3-year-old and a tube down his throat.
So, as you can see, there is a whole lot going on, and it's really hard to tell who's telling the truth and who's lying. But I found this follow-up hearing from middle of September where they're going over how they're going to separate things for the divorce. So here you go.
Could you log off and log back in and start your video, please?
Yeah, start. I don't know if my screen's cracked. I don't know if my camera will work.
Okay, no harm in trying. You still have time to log off and log back in.
So log off and then get back on?
Yes, please.
Okay.
Thank you. Hello, Ms. Sheldon. How are you? I can't hear you. I just want to make sure I get your audio, that your audio is working.
Yes,
Yeah.
hi.
Okay, sounds good. Thank you. Good. How are you? And then Mr. Reed, it looks like maybe there's something in front of your camera.
I'm looking right at my screen.
Oh, okay. All right, we'll be getting started shortly.
Thank you.
Okay, let's go ahead and take up the next matter in the family docket, and that is Reed versus Reed. It's file 22-17030 DM. We have two motions that are set today. The first is a motion to refer the issue of spousal support to the friend of the court. The second is a motion to restore marital property to the estate. Court should note that it looks like an order with regard to that particular issue has been signed. I'm not sure how that occurred. It may have been misfiled or sent to the court. Regardless, let me just make sure, because I know that we touched on this issue the last time we were together. Ms. Sheldon, you're here on behalf of your client, the defendant, and was there a resolution of this issue, or was that simply a proposed order that you were filing with the motion that we have separate today?
That is correct, Your Honor. There was no resolution. It was just simply a proposed order.
All right. In which case, it does appear that the order was signed improvidently and in error. So I'm going to go ahead. That's interesting. Just a moment. I see that it was proxy signed by my staff. Regardless, I'm going to go ahead and withdraw the signature on that. That doesn't mean that I won't sign it if I conclude that it's the proper thing to do after both parties have had an opportunity to argue the motion. But with regard to the signature dated 9/11, that signature is withdrawn and that order is nunc pro tunc. All right, with us today we have Ms. Sheldon. Ms. Sheldon is the defendant's attorney. We have the defendant, Kelly Goggins Reed, with us. Also, Mr. Reed is here. Neither of them are appearing by video. I understand we've had some issues with Mr. Reed's phone, but he can hear me at this time. Is that correct?
Yes, sir.
All right, very good. Good morning. And Kelly Goggins Reed, you can hear me as well. Is that right?
Yes, sir, I can.
All right. And are you appearing by video today?
No, sir, I am not.
Okay. All right, Ms. Sheldon, these are your motions. Let's go ahead and hear argument, please.
Your Honor, addressing the motion to restore the marital property back into the marital estate, I did receive a copy of the promissory note, but the note does not state any reference to the specific property, as well as the fact that it doesn't indicate how many payments were made on that property. Also, the fact that the property was transferred to a third party shows that there was no issues as to the debt or mortgage on the property. And I don't believe that the court has any reason not to order that property back into the marital estate.
Michigan is a community property state, and what that means is any property acquired during the marriage, with the exception of an inheritance or a gift, is jointly owned and needs to be divided equitably. So what that means is the fact that this property, even though it is just in Mr. Reed's name, that doesn't matter. It is still considered marital property, community property, and it has to be divided equally between the two parties.
Well, let me ask you this question, because I think the existence of a promissory note does at least create a presumption that there has been a transaction. But as I understand it, your client is contesting the signature on that document. Is that accurate?
That's correct, Your Honor. There was no, my client is not on the property itself. Everything that they own during the marriage or purchased during the marriage was all purchased in Mr. Reed's name. My client had no reason to sign that loan just because the signature was there. My client is disputing that signature. That is not hers. She has not seen that document and does not believe that that is her signature.
All right. And with regard to the transfer of property acquired during the marriage, is this a situation where dower would apply? I know we've eradicated dower in Michigan. Is her signature required in order to effectuate a transfer of the property?
I apologize, Your Honor. The question was,
Is her signature required in order to effectuate a transfer of the property out of Mr. Reed's title if the property was acquired during the marriage?
No, Your Honor. Since he had only put his name on the property, I suppose there was nothing stopping him from transferring the property under his name that was required during the marriage. However, they are married, and that this is marital property, and that this property should return to the marital estate.
All right. I think you're going to need some testimony with regard to this. If you're contesting, well, let me back up just a moment. So your argument is that even if it's a valid signature, the promissory note itself is not necessarily impactful because the property was acquired during the marriage and is therefore part of the marital estate. Is that what I'm hearing from you?
That is correct, Your Honor.
This one took a bit to figure out, so a huge thanks to Big Tiff Dog and J. Robine Law for their help. What happened was there was a piece of property purchased. It was a vacant piece of land shortly before the marriage ended. The purchase was only in Mr.'s name. However, there was a loan secured that was not a mortgage, but it was in both of their names. After she left, he wasn't able to make the payment, so he worked something out where his parents would take over payments or whatever it was, and they signed a promissory note to cover the cost. So there really was from what I can tell, there was no profit from this, but they didn't fill out the paperwork correctly to say that there was no profit. So that would have solved the situation. But she's also alleging that she never signed that note. So that's a whole nother issue.
And being transferred out during the marriage, you're saying that Mr. Reed had the right to do that, that there was no dower interest. He had the right to do that, but he did so based on the arguments you've been making in this matter. He did so in order to protect the asset from marital distribution. Is that accurate?
That is accurate, Your Honor.
All right, then I'm not sure additional testimony is required unless you wish to call a witness.
No, Your Honor.
Okay, Mr. Reed, do you have a response?
Yes, sir. I'm apologizing, sick. Needless to say, she had said that there's in the promissory note there was no amount of payments made. I'd never known on a promissory note that they give you a new one every time a payment's made. The property was bought, and there was time period between getting the property and Kelly leaving to go to Texas. There was one payment that could have been made in that time period. So marital assets would have contributed 500 and whatever it was dollars towards the equity in the property, I guess you would say. There was no money from the marital estate that paid towards the property minus 500 something dollars, if that's the way you want to look at it. She did sign the paper. There was a loan made to acquire the property. Obviously there's records of that, and there's no reason to transfer it. I listened to the owners of the property, basically, that owned it because of the loan, when I couldn't afford to pay, obviously, because there's no money to pay any bills. They had told me that they would work something out with my parents, which they did. My dad had actually built something prior to all this taking place for them to stay there when they came to visit. Needless to say, I followed by what they said. The person that is over that had the loan, I guess was instructed that was fine by his lawyer that he has for his trust, because it was money borrowed from a trust, not from an actual individual. And his local lawyer that he has here, I guess gave him the advice of that. I just did what I was told for transferring.
Okay, thank you. Do you have a response, Ms. Sheldon?
No, I don't.
Okay, the question before the court with regard to the first motion is whether or not certain property that was acquired during the marriage by titled to Blake Everett Reed should be considered to be marital property. That property has since been transferred from Mr. Reed to a third party, and the defense is seeking to have that property restored to the marital estate so that it can be divided between the parties as part of the resolution of this case. The defense has presented a copy of the warranty deed. By the way, the defense's motion is affirmed by the defendant who signed the document, and as such, the statements therein are her statements for purposes of this court's review. The defendants have filed a copy of the warranty deed that shows that this property, which is in Rapid River Township in Kalkaska County, was conveyed by Mr. Reed, was conveyed to Mr. Reed by Mike Cummings. This occurred on or about June 16th of 2022. It was conveyed pursuant to warranty deed for the consideration of $28,150. The defense has also presented a quitclaim deed from Mr. Reed, the plaintiff in this case, to Kathy and JT Shanks, husband and wife of Morro Bay, California, for the same property for nominal consideration of $1. This document was signed by Mr. Reed on January 5th of 2023. This lawsuit was filed in 2022, in October of 2022. Just so the parties are aware, the court is reviewing the orders, and there is a mutual restraining order that was issued by the court on February 6th of 2023. Sorry, February 10th of 2023. It was executed with the agreement of the parties and their counsel at the time to restrict alienation of real property. The transfer that occurred with regard to this property from Mr. Reed to the Shanks family, Kathy and JT Shanks, occurred a month prior to the imposition of that mutual restraining order. So the transfer itself is not directly covered by the restraining order or in violation of it. But the question now becomes whether or not that transfer was an attempt to move property outside of the marital estate that should be included in the estate for purposes of resolution of the assets of the estate. There is a promissory note that has been provided by the defendant that purports to require that Blake and Kelly Reed, as borrowers, pay a certain amount of money to Morrow Family Enterprises, LLC, which is an entity that the court has no awareness of, given that they're not the party that drafted the warranty deed to Mr. Reed. But regardless, this promissory note has been provided. The promissory note does not specifically identify the property. It says, however, that this security is property on North Wheeler Lake Road in Kalkaska, Michigan. The subject property in the warranty deed is commonly known as 7653 North Wheeler Lake Road. So while it's inartful, it does appear that the promissory note is attempting to secure or use as security the subject property that we are discussing in Kalkaska County. The document, the promissory note, does bear the signatures of purported signatures of Mr. Reed and Mrs. Reed. Those signatures apparently occurred on or about June 20 of 2022. So we have a situation here where we have a promissory note that was executed back in June of 22 by both parties allegedly being responsible for the obligations on that note. However, the property was only payable, only titled in Mr. Reed's name. And there may be reasons that was done, but it does appear that the promissory note signed by both parties, again, does reflect the subject property of the warranty deed and the quitclaim deed that we've already discussed. It should be noted that the property itself was transferred by Mr. Cummings to Mr. Reed on June 16th of 2022. That is just before the purported promissory note, which I said was dated June 20th of 2022. So the two events occurred at about the same time. That is, the subject property was transferred to Mr. Reed alone, and the promissory note with the property being held as security was signed by both Mr. Reed and purportedly by Kelly Reed. It should be noted that Kelly Reed disputes that she signed this document.
I think he's just like talking out loud while he's trying to figure everything out. But basically, they bought the property, they got a loan and used the property as collateral. The property was only in his name. The loan was in both of their names. She says she didn't sign the paper for the loan. Okay. Let's go. 20 minutes now. We figured it out.
So there is no violation of the mutual restraining order in this case, as the property was apparently transferred by Mr. Reed to through quitclaim deed just prior to the entry of the mutual restraining order in this case, which leaves the defendant to seek to have the transfer by quitclaim deed handled pursuant to the court's equitable powers. The court does have the authority under Michigan law and jurisprudence to be able to resolve property disputes like this, to determine what matters are and are not part of the corpus of the marital estate. And the court frankly has some questions here with regard to the subject property. Mr. Reed has indicated through his statements that payments were being made on the underlying promissory note, but were behind, and that in order to protect the property was transferred back or transferred to apparently an entity that may be associated with Morrow Family Enterprises LLC, the holder of the note. Mr. Reed didn't really explain well exactly the relationship between those parties. I'm a little confused about it. I don't know if Morrow Family Enterprises has any bearing upon the recipients of the quitclaim deed, that being Kathy and JT Shanks of Morro Bay, California. There's been discussion about the Shankses being related to Mr. Reed. That's not entirely clear to me as well, but there's been a representation that the property was transferred to his parents. This is all suggesting that there's more than meets the eye with regard to the manner in which the plaintiff disposed of this subject property. The fact that both parties to the marriage were required to be involved in, were on the hook for repayment of this promissory note, but yet the property was only titled to Mr. Reed, creates some questions as to whether or not the property should remain as part of the corpus, and whether or not Mr. Reed had the ability to transfer the property by quitclaim deed to Mr. and Mrs. Shanks. Frankly, the information regarding those transfers is underwhelming on this record, and the court needs more information with regard to the asset itself, and whether or not these transfers were intended to be part of a normal resolution of a dispute with regard to payment of a promissory note, or were actually intended by the plaintiff to transfer assets out of the marriage in order to avoid some kind of splitting of any equity that might have developed in the subject property. For all those reasons, it does appear to me, based on the record, which again is thin at this point, I still have questions. But as a result, I do think that the property does need to be restored to the, I'm going to restore it to the marriage. It was in Mr. Reed's name. It will stay in Mr. Reed's name for the time being. It will be subject to the court's order with regard to disposition of marital assets. That is the mutual restraining order, meaning that it cannot be transferred out of Mr. Reed's name until such time as the court has had an opportunity to review and approve that transfer. And again, this transfer to the Shankses may be entirely appropriate, but something looks fishy here based on the record that I have, and until the court knows more, that property should remain as part of the marital estate, as it was clearly transferred several months after the filing by the plaintiff of this particular lawsuit. The court would also note, of course, that the suit, the action for divorce was dismissed at one point or pended at one point administratively. And so it's had kind of a circuitous route through our system. But regardless, if there is property that should properly be part of the corpus of the estate and divided between the parties as their interests may appear, then the court should use its equitable power in order to effectuate the presentation of that property in the estate, and I will do so. I've had a chance to review the proposed order that has been provided by the defendant with regard to the court's decision. I think that the proposed order is consistent with my decision. So I will go ahead and execute that, but I'll need the defendant to refile it with the court so that parties can submit objections if they have any, and I'll sign it under the 7-day rule. Ms. Sheldon, do you understand?
Yes, Your Honor.
Okay, thank you. Let's go ahead and take up your other issue, which is the spousal support issue and referral to the front of the court.
Yes, Your Honor, thank you. Defendant files a motion to refer the spousal support order. It was ordered through this court after a hearing in February. The order was dated March 9, 2023, and effective March 1st in the amount of $350. We have not received any payment from the plaintiff, and we are requesting that the court refer the matter to front of the court so that payments can be made through the court system or the FOC system, Your Honor.
All right, Mr. Reed, do you have a response?
Yeah, yes, sir. I apologize. I gained employment after the time that we had the talk about the spousal support. I received a letter from the state or the friend of the court. I'm not entirely sure at this point, saying that everything, child support and the spousal support, would be taken out of my check automatically. And I assumed it was, being how I bring home on average about $1,200 a month, but can't even pay my rent, much less anything else. So I assumed that everything was taken out according to the letter that I was sent from the friend of the court. I don't have any other record of anything other than, I'm sure it's happens in every case that they send a letter when you obtain a job and they automatically take it out. That's all I know is everything. I just figured with what I make, and I'm only bringing home $300 a week. I just assumed everything was taken out like the letter said.
All right, I'd be glad to hear an argument regarding amounts at some point, or have the friend of the court hear an argument regarding amounts being deducted. We had a hearing. I made some decisions with regard to what I thought was an appropriate payment amount. That has been in place since March. No payments have been made since March. It's now 6 months later. The plaintiff believes that was under the impression that those amounts were being taken out of his paycheck directly. The plaintiff is right that the friend of the court does take out child support directly from your paycheck. And if referred to them, they can take out spousal support. It doesn't appear, based on the representations of Ms. Sheldon, that that's been occurring. Let's go ahead and make sure it does. So I'm going to grant the motion with regard to transfer of this matter to the friend of the court for purposes of assessing spousal support pursuant to my prior order to be deducted from the the plaintiff's paycheck. And Mr. Reed, if there are issues that you think are legitimate with regard to those amounts, there's a process by which you can challenge that, but you got to pay them first, okay? And it appears that you're behind pretty significantly in terms of that payment. That's got to be caught up. So let's get that taken care of. And once it is, I'm certain that we'd be glad to hear any argument with regard to what you owe. The complaints that I've heard are that you simply haven't paid, and that's not acceptable. All right, Ms. Sheldon, is there anything else that you wish to address today?
Yeah, and I did provide the court with the proposed order. However, I found some clerical errors on that, so I'll be submitting another order under 7-day with the uniform support order.
All right, let's go ahead and have you do that, please. I'll expect orders from you on both matters then under the 7-day rule.
Thank
anything
you.
else, Ms. Sheldon?
No, Your Honor. Thank you.
All right, anything for you, Mr. Reed?
Yes, sir. From my understanding on the first case, you want the property transferred back to my name. I'm guessing the court orders that to the legal holders of that property. I'm not sure how that works.
Sure. What I've done is agreed to issue an order that that grants the motion to return and does. By the way, Ms. Sheldon, the defendant brings up a good point. I have not made a conclusion at this point that it was fraudulently transferred to the Shankses. So that language needs to be removed from the proposed order.
Okay.
Rather, what I've simply determined is that the property was moved out of the estate in an untimely way and needs to be returned. But back to you, Mr. Reed. What I've done is essentially indicated that and here's how the order should read, that the quitclaim deed was ineffective. So it's like it never happened. The property was not quitclaimed to the Shankses, to your parents. Therefore, it's still in your name. And by the way, Ms. Sheldon, it probably makes sense that you draft this proposed order in a manner so it can be recorded as well.
Okay. Commissioner.
So they may have an interest in participating in this litigation, and they can certainly talk to an attorney about how to do that. I can't give you advice from the bench or them advice from the bench.
Yes, sir.
Okay, but
Can I ask?
I think it's a good idea to get everybody in here. We can maybe have a discussion regarding everybody's role, so I know exactly what happened and can make a decision regarding how it should be disposed of. Go ahead, Mr. Reed. You had another question?
Yes, sir. I apologize. On the first hearing on the property, Ms. Sheldon stated that, correct me if I'm wrong, I've tried to get records, stated that she was unaware that there was any type of loan or promissory note on the property, that was the first time that she had heard of this, when in fact there was emails back and forth, and she was aware of that. I just want that to be on court record. She was aware of it, even though she stated it was the first time. When you asked why we were here, when there's a promissory note, and she had stated that it was the first time she had heard about it, yet she was aware, and there is emails documenting that.
All right. Well, they're not before me right now. They're not part of the record. If you remember, I also said that the record I thought was incomplete and frankly a little confusing to me. You're expecting me to understand the intricacies of your relationship with regard to this property, your parents and your wife. And I don't. I deal with thousands of cases. This is one of them. And
Yes,
the information needs to be presented to me so that I can make a reasoned and fair decision about them. But based on what's before me right now, I've got some concerns about why this property was transferred out of the marital estate when it was. Therefore, I'm going to keep it in the marital estate until such time as we get clarity on this. You may be, as I said, you may be 100% correct, and this property perhaps should have been transferred back to your parents, although I don't know who the promissory note was with. Nobody's ever explained that to me, but that's another story. All of those things need to be part of the resolution of this case, and that's why I'm bringing the property back. Okay, do you understand, sir?
Yes, sir.
Okay, very good. I would commend you. I know you had an attorney, Ms. Neros. I would commend you to an attorney. It would be helpful for you to have someone who understands these legal concepts and can represent you in court. I understand that may not be possible given the financial situation that you were describing, but it's appropriate for me to advise you that it's a good idea to have an attorney. And frankly, if you had an attorney helping you with some of these property transfer issues, we might not be having this discussion today, okay?
I wish I could afford one. I understand. Yes, sir.
All right, very good. All right, thanks, everyone. We'll look forward to Ms. Sheldon's orders. Thanks.
Thank you.